Hey, so there's a lot of people out there that talk about single member LLCs and they lack asset protection. Well, in this video, I'm going to break down what you need to create a single member LLC that will actually provide you asset protection. All right, let's get started. Okay, so here's the deal. You watch video after video on YouTube and there are individuals that tell you, oh, single member LLCs, they offer no asset protection. Well, my point in bringing this video to you is, who are these individuals that are telling you that single member LLCs do not offer asset protection? Many of them aren't even attorneys and they don't even understand how the LLC works and where the asset protection features come from. Because there are things that you can do to ensure that your single member limited liability company will protect you in the event of a lawsuit. So yes, there are situations where LLCs do not work if they're a single member, but you can work around that if you only know the things that you need to have in your operating agreement and where to set it up to get this type of protection. All right, so I've got a list here of things I want to go through with you that break it down, that are very important if you're setting up a single member LLC, which you should ensure that is in your LLC to make sure if a lawsuit happens, you have asset protection. All right, number one, the first thing we want to look at is where the LLC was set up. Now, this is the big issue here, and that's what everyone clamps onto when they're talking about single member LLCs. They'll say, hey, Florida, they don't offer asset protection. And they'll throw out other states where single member LLCs specifically do not provide protection for their members. Now, what are they referring to? Well, they're referring to this when they're talking about single member LLCs, that if you set up an LLC and you're the manager of that LLC and you're also the member, hence the single member LLC, there's only one member. And if something happens on the inside, let's add a piece of property inside of here. This is not the asset protection they're referring to. So if something happens on the inside of your LLC with a rental property, absolutely this single member LLC is going to protect you because that liability is going to stay contained inside of this LLC. It's not going to spill out and hold you personally liable. No, what they're getting at when they talk about this is the outside threats. That is, you get sued individually. So if a creditor is coming after you and they obtain a judgment against you, let's say for $200,000, and they have this judgment, then the question is whether or not they can take that judgment and then use it to break your LLC and get up here into the actual assets themselves. Now, it depends on the state in which you set it up. So if you set up a limited liability company with a single member in Florida, well, obviously under Florida law, Florida does not recognize charging order protections for a single member LLC. And see, this is what's really important when you're creating single member limited liability companies of which you're going to be the member. You have to choose the right state. So if I set up my limited liability company here, we set this one up in Florida as a single member LLC, and I'm down here as the member and I'm involved in a lawsuit, you're right. Single member LLCs do not offer asset protection because under Florida law, the creditor can take my LLC. They can foreclose on my LLC interest. It's right there under the state statute. However, if I set up a single member LLC, for instance, let's say in Wyoming, so I created a Wyoming single member LLC and I'm the member, and the same thing occurs and there's a $200,000 judgment entered against me. Oh, well, now you have to look to Wyoming law. And under Wyoming statute, their charging order statute, not only does it state that charging orders are the sole and exclusive remedy to a creditor, it also states that that is the sole and exclusive remedy to a creditor of a single member LLC. So you see, this idea that single member LLCs do not work is just patently false. You just have to understand the state in which you're setting it up in. So that's the first thing. If you're setting up a single member LLC, make sure you're setting it up in a state that recognizes charging order protections as a sole and exclusive remedy, and it specifically recognizes that single member LLCs are covered. All right, now that I've told you that, so let's go back to my example that I originally proposed. So we have a Florida single member LLC that we've set up to own a piece of rental property. Oh, wow. Gosh, I made a mistake. I've got a single member LLC in Florida. It doesn't provide protection. Well, how do you fix that? You see, this is a really simple fix. All you need to do then is set up a Wyoming LLC right here, of which you will become the member of. And now make your Florida LLC owned by the Wyoming LLC. hey, I just solved my problem. If I get sued and somebody asks me, do you own an interest in a Florida single member LLC? The answer to that is no. I don't hold an interest in a single member LLC in Florida. I own one in Wyoming. And in Wyoming, they recognize charging order protections for single member LLCs. And if you're not up on charging order protections, all that means is that they can't take your LLC interest from you. They can't get into your business at all. They just got to sit back and wait until you decide to take out a distribution. And if you don't take out a distribution, they never get paid. That's why it's so important when you're setting up LLCs that you have charging order protections. Okay, so what's the next thing you need to make sure of? Well, this comes down to your actual LLC, single member LLC operating agreement. All right, so the operating agreement is very important when you're creating single member LLCs, because what you want to do is build in what I refer to as poison pill remedies. That is, if somebody's coming after your LLC, or you individually, and they're trying to break into your LLC, well, we're going to do everything we can to deter them. And so one of the things that I like to build into my operating agreement, and I suggest you do the exact same thing, is that you have indemnification provisions built inside of there for both the manager and the member of your LLC. All right, guys, real quick here. For those of you that say my handwriting looks like chicken scratch, you're 100% accurate. But anyways, back into this. So what does this mean? Essentially what it means is this: when you put these provisions in there, it states that the company shall indemnify, defend the managers, directors, or officers of that limited liability company, and agrees to hold them harmless and to take any action necessary for either the sole member to pay off any debts or obligations of that member or manager as a result of the lawsuit. So what it's essentially saying is that you can take your assets, right? So if I have a rental property in here and you're coming after me, I can sell my rental property and use those proceeds to defend myself. If you get a judgment against me, I can sell that rental property and use those proceeds again to protect myself in defending against that judgment. And so this is where it puts a creditor in a unique situation. That is, if they're coming after you and they think they're going to get these assets, but instead you're telling them, hey, listen, give it your best shot, but I'm going to indemnify myself, and that money is going to go to my attorney before it's going to go to you. So this is a great provision to have in a single member LLC. Now, another provision that you want to have in there that I think is equally important is the restriction on the transferability of a single member's membership interest in an LLC. What do I mean by that? Well, if you have a creditor, obviously, this creditor is trying to get after your interest in this limited liability company. And they're going to use every legal tactic they can in order to grab onto that interest. So here's what you put inside of your operating agreement: that the sole member cannot transfer their interest to a third party. In fact, what I like to do is only provide limited circumstances in which the member can transfer their interest. And so the way we set it up in our operating agreement is that a single member, a sole member of a single member LLC, can only make permitted transfers. And those permitted transfers are typically to a spouse. Okay, they're to a living trust if you set up a living trust, or they can transfer them over here to another business entity that is owned by that member, or even children in some instances. So we limit the class of interest, businesses or individuals that you can transfer your membership interest to, and who's specifically excluded? Creditors. So again, we want to build that language in. So that means also that you want to bury on top of that assignee language. So the thing is that if any one of these provisions fail, you got to have backup provisions there, again, to make sure that your single member LLC has necessary protection. So the next provision I want to bury into my operating agreement to stack on top of what I've already discussed is assignee language. And it states this: hey, if a court wants to give away my interest and they want to ignore the law, well, the fact of the matter is that the member, the person that grabs my interest, can only become an assignee. They can't actually become a member in my LLC. That's important, and here's why. Because the members have certain control over the limited liability company, maybe the ability to replace a manager of an entity or dissolve out the company. So we do not want a creditor to ever obtain member status. As long as we keep them as an assignee, that means they would be entitled to any distributions we're not going to make, of course, but they don't have the control. So that's why having a provision in there, what we call assignee provisions, is crucial beyond just the restrictions of transfer provisions, because you never know what's going to happen with a court. Now, the other provision I think is extremely important because this is a single member LLC. You want to make sure that you have a provision that prevents any third party from removing a manager, because one of the tacks that creditors are going to take is they're going to try to replace the management of a single member LLC, because their argument is going to be, hey, it's just you. You're the member, you're the manager, you're going to do things for your own benefit. So let's replace you. We'll leave you as a member, but we'll put someone else in as a manager to control the assets. Hey, well, I'm not going to allow that to happen, because inside of my operating agreement, I'm going to state that no one can remove the manager of this LLC. So once you appoint yourself, there's really no reason why you need to remove yourself and appoint a new manager. In fact, what you can put inside of there, which is I like to do this, is that the only party that has the power to remove or replace or add managers is the existing manager. So when you set up your single member LLC, you appoint yourself essentially for life. And if you don't want to keep serving, you as the manager of your single member LLC, you can appoint someone else. Now, if you set up a single member LLC, again, in the state that does not offer strong charging order protections for single member LLCs, as I stated, don't fret. Make sure you've got that holding company there. But the last provision I think that you should have in these operating agreements is what is referred to as a decanting clause. Now, what a decanting clause means is that if I have a limited liability company here, let's just go back to Florida, since that's the one everyone likes to pick on. I've got my Florida single member LLC. Well, we put clauses in all of our single member LLCs that basically allow you, if you're being attacked in Florida and they're coming after the Florida LLC, you can change this to a Wyoming limited liability company. So what you do is you pick it up and you move it out of Florida and you put it into Wyoming, and now it creates a problem for them because it's no longer subject to Florida law. Now we're dealing with Wyoming, its charging order statute and protection for single member LLCs. But in order to move an entity like that and defeat a claim that someone may bring that, hey, this is a fraudulent transfer, you got to put into your operating agreement this decanting clause that allows you to make that move at the outset. So it's not something you're adding at a later date. So when it comes to single member LLCs, listen, don't fall for all the fear mongers out there that tell you single member LLCs do not work and they don't provide asset protection. They do. I've been using single member LLCs for 18 years and putting together structures for our clients, and they absolutely work, but there's ways in which you need to put them together to ensure that you're going to get the necessary protection by looking to the right states and putting the proper provisions inside of your operating agreement. Hey, listen, if you want to learn more about how to set up a single member LLC the right way, I would encourage you to click on the link below in my show notes to get a free strategy session with my office. All you got to do is click on that link. It'll take you to a form. You just sign up and we'll set up a strategy session for you. It takes about 45 minutes. We'll go through your business, talk about taxes, asset protection, and what you should be doing to look to move the ball forward to give yourself success in whatever it is you're doing. Take care.